All right.
All right, good morning. We are back in Senate Judiciary. It's February 21st. We have Senator Bohosky providing some introduction of S54.
Absolutely. Thank you. Senator Tony Bohosky for the record. So S54 would decriminalize consensual adult sex work. All of the laws that we have on the books related to human trafficking would remain intact, and actually the evidence shows would be bolstered and strengthened by decriminalization. Our current laws on sex work were written well over 100 years ago, and they don't only prohibit paid sex, they also prohibit indiscriminate sexual intercourse without hire, which is a somewhat undefined term. We don't really know what it means. Does it mean sex outside of a marriage? Does it mean having more than one partner? We don't know. And that also is categorized under our current sex work policies. So our current laws really actually are not in place to protect anyone, as we've heard kind of again and again and again in this committee. Criminalization comes with all kinds of challenges, can actually lead to violence and exploitation, create stigma. So by criminalization, we're actually making it harder for trafficking victims to come forward, or people who have been harmed or abused to come forward. A September poll of the state of Vermont showed that 50% of voters think sex work should be decriminalized, and only 26% believe that it should remain a crime. I know those numbers don't add up to 100, because that means there's a percentage of people that actually just think it should be legal, not just decriminalized. So this bill does not legalize sex work, it decriminalizes it, much like many years ago we did with cannabis. We didn't say, sure, it's legal to have cannabis. We said, you're not going to go to jail. It becomes a civil issue. So over the past couple of years, Burlington and Montpelier have removed some bans on prostitution from their ordinances. We have expanded our ban on police sexual violence as passed in H18, which allows sex workers and survivors of trafficking to report crimes to law enforcement, seek medical attention, and not be in fear of their own arrest, which is a really important move forward. And decriminalization is the next step in moving forward to protect people. It's really crucial, as I said, because it protects the rights and safety of sex workers. It allows for people who have been trafficked to access help and not be afraid. And it allows people to work without the fear of criminal prostitution. Laws against sex work shove things into the shadows, and it makes people vulnerable to violence and exploitation. Things in the shadows can't be properly regulated and looked at. So decriminalization would create a safer environment by enabling sex workers to practice harm reduction strategies, shifting negative stigma that makes sex workers vulnerable to bad actors. And the shift would help ensure that individuals can work with autonomy and dignity without being criminalized for how they earn their living. During the 6 years after the public became aware that indoor prostitution was decriminalized in Rhode Island, so from 2003 to 2009, reported rape cases decreased by 31%. The statewide incidence of gonorrhea dropped by 39%. And since New Zealand decriminalized over 20 years ago, rates of sexual violence have decreased. And there's been no increase in the prevalence of prostitution, and sex workers have been able to improve their relationship with law enforcement. So this is really a bill that benefits everyone. It benefits sex workers, it benefits trafficking victims, it benefits law enforcement, and it benefits our whole community. So, contrary to common misconceptions, decriminalization of sex work does not lead to an increase in human trafficking. Laws often confuse consensual sex work with human trafficking. Trafficking involves force, fraud, or coercion. Criminalizing sex work actually makes it, as I said, more difficult for those victims to report their exploitation, because they don't know if they're going to be treated as a victim or a criminal. So I think that that's a really important piece here. In the places where sex work has been decriminalized, trafficking has decreased. Law enforcement is able to focus on violent crime and genuine exploitation instead of arresting consenting adults. And I think the distinction is just really crucial for us ensuring that the victims of human trafficking are not continuing to be marginalized. Additionally, decriminalization benefits public health by enabling safer working conditions, access to health services. In jurisdictions where sex work is illegal, workers face risks such as being pressured into unsafe practices or not being able to carry condoms for fear of being arrested. Whereas when sex work is decriminalized, sex workers are much more likely to be able to practice safer sex and have access to health services, which lowers the incidence of sexually transmitted infections. International public health agencies, such as the World Health Organization, have recognized that decriminalization is actually a key strategy to eradicating HIV transmission. And so decriminalizing consensual adult sex work has broader social and economic benefits. Resources that are currently spent on policing consenting adults can be better allocated to investigating serious crimes like assault and trafficking. So it also reduces racial and gender-based disparities in law enforcement where marginalized groups, especially people of color, face disproportionate arrest. Decriminalization is really the only approach to governing sex work that is grounded in recognizing everyone's human right to bodily autonomy. So what this bill would do, as I said, is it's a relatively simple little bill. And it, again, does not legalize sex work. It decriminalizes consensual adult sex work, including indiscriminate sex, which again is a somewhat murky term that could actually make probably many people in this building classified as a sex worker under the current Vermont statute. So that is my sort of overview of the why and the what, and I'm certainly happy to take questions.
Thank you. And sorry if you said this and I missed it, but do you have any information on how often this is charged at all?
I don't actually have any information on how often this is charged, but I think that would be a really important question to get answered.
Any questions, comments?
I was curious about the same thing, how often it is prevalent for Vermont, how often it's charged.
I suspect that the Department of State's attorneys might be able to more easily answer that question. I did not have the time for today to go through every county's charging, but I imagine that they'd be able to come in and answer it for us.
Thank you.
Yeah.
Anything else? Oh, great. Well, thank you.
Yeah.
Thank you. We were going to have Senator Weeks come in, and I think that is the last bill that we need to have introduced, but he had to reschedule, so he'll be coming in next week. I do want to shift gears real quick to talk about S12 and the testimony we heard yesterday from the Defender General's office. And thoughts from the committee as to timelines regarding voting, making any changes. I think that the petitionless ceiling is still something that we need an answer to. So,
Yeah, Judge Zone was going to try to extrapolate out the impact of that narrower set of petitionless ceiling. So I think I already told you this. I may not have told the whole committee. The report on petitionless ceiling applied to like if we were to move to a completely petitionless system. Some states do that. And the report included the resources that would be needed and the time that would be needed. But what I was asking for is actually a really narrow scope of petitionless ceiling for things that are no longer crimes. But the report, like I said, just looked at the gross system. It didn't look at that narrower piece. So Judge Zone had said he'd try to extrapolate out. And I think everyone else I know everyone else had the report that sort of didn't say they couldn't do it, just sort of laid out what would be needed to do it for everything.
I think the other piece also how defense attorneys can access records, sealed records. I don't think we actually heard that from Marshall yesterday. I also don't think I forgot to ask the question actually, but this is a bill that I'd like to get out ideally next week. And I don't think it's really a surprise that the Defender General voiced opposition to it.
Wasn't Marshall gonna come back though? Weren't there some outstanding?
Yeah.
Because I know I had
Next
questions for
Thursday,
Marshall
Friday.
because he kind of ran out of time.
Yeah, yeah, I think you mentioned Thursday or Friday.
Friday, yeah.
He's out of town.
Yeah. And I suppose, what were your questions from both of you?
I'd actually have to try to think of them. Like I'd have to go back and watch his testimony from the other day to remember what they were or dig through my stuff to see if I wrote them down.
You remember your questions?
No, my only thought was, did we nail down the 3710?
Oh, yeah, so there's no 10, my understanding, because the 10 was connected to that old super ceiling concept.
Okay, there we go.
Yeah,
Yeah.
so we're not doing really.
Yeah.
The 3 and the 7, we had the crime research group in,
And then,
and I mean, they provided helpful and good information, but I don't think we got a super clear answer on the 3 and the 7.
no, I think because it was like a definitional thing, right?
Yeah, I think it was more of like, well, it depends, you
Yeah.
know, on the crime and so on, but I mean, I'm still,
And they only need to go over to 36 months, right? Wasn't that what
Well,
their
there is-
testimony?
Their research did
yeah.
from a research standpoint.
Right.
I feel like last year I saw data that showed that somebody who, after 10 years, doesn't commit another crime is just as likely to commit a crime as somebody who's never committed a crime in the first place. And I'm trying to remember where I saw that.
It's not a good defense.
Yeah, I know.
Was that the testimony? Because I know Michelle had indicated that Senator Sears had historically, and maybe these were the people that were just here, but I think they were Vermont specific, was from the Council on State Government's crime lab. Because the research or what they presented, it seemed pretty compelling to me that, I mean, when you looked at that recidivism rate, it dropped very significantly after a year. By the time you were at 3 year, there were 2 people that was, so like, when I look at that graph, like, no, it didn't and research never will provide the, like, this is 100% the answer in the real world, but it seemed pretty compelling to me.
Yeah. I think also, I mean, realistically, you know, with most felonies, there's going to be a couple of years at least from that initial charge to the completion of the sentence. You know, it's gonna take, if you're moving fast, you know, it's gonna take at least a year to resolve that case. You know, maybe you have a really good offer at the very beginning. And then, you know, you have a couple of years of probation, or, you know, you serve a couple of years. You're looking at somebody who is done with their sentence and eligible for expungement or / sealing after around 10 years. That's an approximation, but that's my opinion on it.
Their data too, like from the time of the offense. So even in the, like, they're actually looking at a shorter window than we're talking about. Even like when we say 3 years, we're saying 3 years after the completion of everything. Their 3 year window was from the charge.
Yeah.
And even then, their 3 year window, 2 people recidivated after 3 years. So I think it's such a longer runway that we're talking about.
Yeah. Yeah. And
No, I was just thinking, it popped into my head about what Defender General is talking about, was the expungement in the prospective versus what's a prospective versus retroactive, and
yeah,
where a person was at in the timeline for that expungement. It was something like that, wasn't it? It was, when were you gonna do the drop dead date where you could still do expungement, or where they were in the process? Wasn't it something along that?
there was, that was a good point.
And that's what you wanted to go back and look at
Yeah.
about what.
I don't know, I mean, I get it for deferred sentences, which Valerio raised. I don't know that I'm fully persuaded, or maybe I'm just not fully understanding that it's problematic to say that, you know, like, let's say somebody's at the 4 or 5 year mark right now between their completion of their sentence and being eligible for expungement for a felony. And we also say right now, okay, sealing and expungement has changed. This law is going into effect. I don't know that there is I don't think there's a constitutional issue. I think it could be problematic if we were to try messing with deferred sentences that are pending. But I don't think it's a major issue. That's my opinion.
Would there be any instance in which, and this is just because I'm a lawyer, in which someone took a plea deal with the expectation that expungement would be part of that plea deal, and this change could impact, because then I think we have a problem.
Yeah, I think there is. Wait, no, that's a good point. We raise that for deferred sentences, but not plea deals that are in process at the moment. So I think, and I don't know what the resolution for that would be, but I think if there is a way to make it clear that it's any resolutions that are entered into after this law takes effect, then it would be applicable. But I mean, I think the reality is also that, some of the folks who are in those pre-plea negotiations of trying to figure out what a good resolution is, there'll be situations where the attorney has to say, hey, the law changed, and that's what we have to deal with. So.
Yeah, I want to make sure that if we're going to change the law, it's not impacting someone that was promised something different, and that should make them make whatever decision they made. That doesn't feel okay.
Yeah. Sir Norris, anything?
We're just spinning here. Representative deals are made. We can certainly grandfather those things in after the date of the past, the law passes, whatever else. I do have a thought. Senator Boski had mentioned from the date of the offense versus I'm still sticking with the date of conviction for the year starting here.
It's my understanding is it starts once the sentence is completed. So
right, but it's my saying you want to go back to not starting the conviction from the time of the offense.
No, I was simply pointing out that the data that the crime research group brought us, that 3-year window they were talking about is from the date of the offense, and the window we are talking about is the date from the. Not even conviction, from the completion of sentencing. And so
probation, your case is wrapped up.
Yeah, my point is that the 3-year window that they're showing, whereby 3 years only 2 people recidivated, we are actually talking about a much longer window because our 3-year clock starts ticking much later than theirs did.
So then my understanding that, just so I know where we are, that we're moving towards sealing.
Yep.
Versus expungement, but the 18 to 21-year-old deferred sentences are still going to be within the 30-day window expunged.
So just to clarify, 18 to 21-year-olds, that's separate from the deferred sentences. But yes, 18 to 21-year-olds still have that 30-day window or time frame in which they can request expungement. And then the deferred sentences, we're not touching those.
Right, and the super sealing that's presented is gone. That doesn't.
Yeah, we're not doing that. It's just that inquest procedure. We need some clarity as to how defense attorneys can access sealed records.
I realize the defense attorney thing is still something we have to kick around because we have discussed on that. Yeah,
I'm going to send Marshall an email over the weekend and hopefully resolve that. And also try to get a chart. I mean, I think he had mentioned that we're taking away offenses that can be sealed, which I
did want to know more about that.
I thought, again, at least from the way I was reading it, is we're adding a whole bunch of offenses, nonviolent property crimes that are eligible for sealing, which I think is a good idea. So I'm going to ask him for that chart as well, and I'll share that with the committee.
and as far as, just so everyone knows, as far as the petitionless sealing, I don't oppose that. I don't think they're ready for that right now financially and IT wise, and that's something I think we should revisit. I think that would expedite the process, and I agree with that, but I just don't think they were ready for that right now. Yes, thank you.
I agree, and that's why I'm not suggesting we enact the full report that as it's suggested for everything, but only for things that are not yet a crime. It almost allows it to be a bit of
no longer a crime?
Yes.
Yeah.
Not yet a crime, I'd almost allow it to be a bit of a pilot in a really narrow group of stuff so that we can kind of figure out what works, what doesn't work. And those things are not currently a crime. So I agree with you that based on what I read from that report, it seems like we could move in that
I
direction.
read that same thing, which,
And that is sort of where why I want Judge Donay to let me know about that much narrower subset that again can sort of act as a pilot and help us gather more information about how we could move in that direction.
and the cost that
Yeah,
goes along with it.
yeah. And so what I'm asking for in this bill to be petitionless is like a tiny subset, not the whole thing.
And what would that be?
Things that are no longer crimes.
Oh, okay. We haven't really identified those other than cannabis.
Right. Well, and it would be, if we were to pass the bill I just introduced, it would then apply to previous convictions for that.
I don't want to throw a wrench into this, but would there be an issue of things that were felonies that are now misdemeanors, or things that were misdemeanors that we then turn into felonies? And would petitionless sealing, do you foresee an issue there?
Well, so this narrow view, perhaps if we were to enact full petitionless sealing like some states do,
Yeah.
I could see that. But because this is very narrowly identified, quite literally to things that are no longer
Yeah.
crimes, I don't think it would have an interplay at all, because it's not things that have changed criminal status.
Yeah.
It's just that really narrow view. And again, I think it almost it doesn't ask that every person in the public who's ever had interaction with the criminal justice center. I know we think the work we do is very fascinating, but I don't imagine they're all watching us to decide what we've shifted and what's
Yeah.
changed. It doesn't rely on them to know. It asks the people who know to take the action. And again, it's a bit of a pilot to get a sense of like, well, what does it cost in this narrow view? What would that extrapolate out to if we were going to do it everywhere?
Well, it is a pilot project, I guess I would lean toward, any offenses, any misdemeanor offenses that were committed that are now no longer crimes. And let's start with that and see where that goes. As far as looking at felonies, I don't know if I could, without having them in front of me, yes, support it. What were the charges? I mean, I don't know. Felony possession of cannabis at this one time, does that fall into the same category? Because it's still a crime today, possession of more than 2 ounces.
Yeah, so if it's still a crime, it wouldn't fall under.
Right.
Like it's literally only things that are now legal.
Or something.
Well,
Surely
that's
we'll have
what we
another
do. That's what we do.
crossovers coming, just so you know.
Yeah.
I also wants this bill.
So, yeah, I'll get some more information from Marshall, and, if it's necessary for additional testimony, and, whatever he sends me doesn't fully answer our questions, then, we'll get that additional testimony. But, if we're able to wrap this up earlier next week, that'd be great.
I think the other question, Marshall, is they opposed the bill.
Yeah, I mean,
And the question was, if we were we're actually adding more offenses to it, and that was the sticking point, I believe.
yeah, but that was one of them. I think he also expressed that this actually complicates things more. I don't
Understand that one.
I mean, I don't remain convinced that it simplifies things, and I recall even the court saying it doesn't actually simplify anything. So I am a little confused as to why we're even doing this, but
It seems, well, I think it keeps things, it doesn't simplify things, but I don't think it necessarily overcomplicates things. But to why we're doing it, I mean, I think there are reasons that defendants may want to access their records after a number of years. And I think there's also reasons that law enforcement may need to access old records after a number of years for the work they do. So that's the underlying reason as to why, in my opinion, this bill exists.
With the goal of still dealing and protecting those individuals for jobs and health.
Yes, and adding more offenses, which are eligible for sealing. Okay, great, that's well. So still pretty early, so let's, are there other bills on the wall that we have right now that folks want to discuss at the moment? I mean, this is just a general committee discussion.
Okay. I just saw Dave outside. he apologized, he said something next week, maybe.
Oh, yeah.
He wants to get in for it, so everybody's been on board.
He said Tuesday or Wednesday. As best as I can remember on the agenda, we're gonna hear some more about S-22. The discharge of firearms within 500 feet of a daycare facility or school.
It's so challenging this year because like I have a bunch of like issues that I do want to talk about, but I don't have language yet because council is so backed up that
Yeah,
all of my bills are still like there's lots of things, but they're not on the wall
and we're
because
a couple weeks away from crossover.
yes, I'm deeply
Yeah.
frustrated with that.
Taking a lot,
What is?
the education taking a lot.
Yeah. I think,
We were warned.
we are also gonna be getting that extradition bill. Soon, and. What else are we getting? I think there was one or two other things that.
The underage, erase the ages, they.
Yeah, next week. Representative Lalonde and Eric, I believe, are gonna be coming in. They wanted to give us a primer, I guess, on raise the age, which I think makes sense because we have a deadline. Regarding that first. Yeah. So we'll get them advanced notice and information about that before crossover so that we don't have to spend weeks and weeks.
What's that, the second week after, or the first week after town meeting, would be crossover?
I think we need to maybe have a conversation as to whether that date is actually realistic, given. I mean, it's a rule we make,
Yeah,
and given that, like, I mean, I have bill requests that I put in November that I still don't have language for, you know, there's what? 10 bills on the wall.
I think it's some guys bring it to the committees or a rule making process, whatever.
I think it's joint rules, but it seems ridiculous to me.
yeah.
Or we should end on our end unless they have on their end. I don't know what the happy medium is there.
Yeah.
If we extended on our end, which I think.
Well, I think this is gonna be a long session. I've
Yes.
heard tell that we're gonna be here until June.
I have also heard that rumor.
I won't be.
What about 61?
Yeah,
What is it?
the not switchblades, the utility knives, you know,
Oh, yeah.
what are your thoughts on that one?
And I want to hear some more information about, you know, if this is a problem of violence, if like, I mean, we heard the presentation, but we don't have any,
Yeah.
how often is this charge, is this actually a problem? Are people being harmed?
I imagine it's never being charged. I've never even heard of it.
That could fall under the expungement or the.
I was just gonna make that,
It
Oh, yeah.
could,
that
Yeah.
connection.
Could be a little,
1959, was it?
1959.
it could, and if someone had that on their record, it would just, if we pass that, it would automatically just go away.
It's kind of, I mean, if time allows, hear from the folks that Senator Brennan brought up.
Yeah,
Allows.
it's not, I mean, I think it's a fine bill and a fine thing to fix. So like, I mean, if somebody has a knife that's 2 3/4 of an inch versus a knife that's 3.5 inches, you can kill somebody all the same with it. But
Has anybody really threatened with this bill?
no.
But that's what I'd just like to hear,
Yeah.
if there is any data and statistics, and there may not be, but I don't think it's doing due diligence to not get that information.
I agree with that. What I'm just trying, I mean, in my mind, I see it as a technical bill that corrects or that changes something that's 70 something years old or however old it is, that no one really uses anymore and was probably based on some fear mongering about switchblades and West Side Story, I guess. But I also am trying to make sure that we have space to hear on other bills that do take up a lot of space, like the ceiling bill, the right to farm bill, and some of the others that are a bit more.
Do we do a miscellaneous judiciary bill?
Yeah.
Oh, okay, we do.
It starts in the house this year.
No, it starts here.
Oh, it starts here this year?
I think I don't think we've got it. I put several things into it.
But we don't have any language.
We don't have language I should follow up on. Because we're pretty close to crossover. I mean, perhaps 61 could go into the miscellaneous bill, but I don't know.
I don't know if that's too, like,
Yeah,
too not technical
yeah,
of a
I
change.
mean, we've done policy changes in miscellaneous bills before,
yeah.
usually not like massive policy.
Yeah,
But
yeah.
like last year in the last biennium in the miscellaneous bill, we aligned, the penalties for powder versus rock
Mhm.
cocaine. Like that's technically a policy change.
Yeah.
What? Where? Good.
Any additional thoughts? Any other bills we want to talk about before we adjourn?
I haven't heard anything in the works, I mean, to be quite honest, I mean, there's a lot of things that we're working on. Jointly, or going to be working on jointly here, but other than the Franklin County Field Base bill, which we haven't seen yet, so.
Let's have a whole host of judiciary bills and I'll double our wall once I have bills.
And no time to take them on.
I know this is part of my frustration with this year.
There's always next year.
There, yeah, well,
Maybe in September this year we can take them on.
We might still be
we're wrapping
here.
up, we're wrapping up education stuff.
What do you anticipate for bills coming home? A lot of them, or do you have any idea?
I anticipate there were,
Well, I've been pretty good so
Raise
far.
the
We're going to get here.
yeah, raise the age is gonna be the big one. There. I still have the, yeah, I don't have the document, that's what it was, but there were several. There's gonna be that hate crime bill that comes over.
It's already over.
It's already over. There's going to be the necrophilia bill,
The what?
the
Yeah.
anti-necrophilia bill, the anti-necrophilia bill. The one that's,
Still don't know
Again,
what that is.
again, what?
Again, what?
the one for Burnett.
Oh, okay, yes.
What else?
Oh. Newspaper.
Would you like an explanation of what necrophilia means?
Not really, because I don't know what we're getting into.
Yeah.
I'm sure there's a few other, I don't know off the top of my
All right.
head what they're doing. Kayla, if you don't mind just adding on the agenda that we talked about S12 today.
Yeah.
Just so that people